Hello, everyone, and a warm welcome to you. Welcome to The Law. Samson Ladi Ayenini couldn't be on the show today, so here I am. My name is Mamavi Owusu-Abuaje. Now, at the heart of Ghana's constitution, the 1992 constitution, is a shared promise that everyone deserves fairness, dignity, and a voice. Now, how do we make sure that this promise isn't just words on paper, but something we feel in our everyday lives? For instance, in how we are treated, in the opportunities we get, and in the respect we show one another. Before we begin, I want us to think together about how justice and the Constitution, the fact that they aren't distant ideas, but living values that shape the kind of society we want to build. Now, that we all get the understanding that the Constitution is a promise. Now, one of the key roots used, or the key tools used in keeping that promise alive is Parliament. Also think about it this way. The Constitution is the foundation. It sets out the rules of the game, the values we all agree to live by. And Parliament is the player on the field, turning those values into laws that guide our everyday lives. But here's the important part. Parliament doesn't stand above the Constitution. It exists because of it, and it must always act within its boundaries. That's how we make sure laws protect people's rights, reflect fairness, and keep power in check. I'm sure you figured out how our conversation will be shaped today. We're talking about the Constitution, but we're also talking about a very important arm, a tool that the Constitution uses, which is Parliament. We'll have a great conversation. We're ready for you to join us, but it will be after this. All right, so today we're talking about upholding justice, the spirit of the Constitution, and we're also talking about subsidiary legislation. My guest seated in the studio, Daniel Krang, is a lawyer, lecturer at Greenfield College in Sonyaing, and a renowned author. He has published several books and articles in law. Also joining the conversation is Benjamin Antiedu. He's a lawyer, he's an author, and parliamentary professional. Gentlemen, welcome to The Law. It's good to have both of you.
Thank you very much for having us.
So, you've all written quite a number of books, and we're going to be teasing our conversation out of the works that you have done. So, first of all, I want us to start from the mother, which is the Constitution. And Mr. Daniel Krang, you've made the arguments that beyond the letter of the law, the Constitution embodies a spirit. So let's, from the beginning, so that everybody can follow us. Can you explain what the spirit is?
All right, thank you very much, and good afternoon to your cherished viewers. I have always told my students that the Ghanaian Constitution is a very special constitution. It is special in the sense that it is one of the few constitutions I have seen and read that makes specific reference to A's letter and A's spirit. So you see and read the Constitution saying that it has A's spirit of the law. So you read a document that says this document has A's spirit. When you read Article 17(4) of the 1992 Constitution, it makes specific reference to A's spirit. So anyone with the 1992 Constitution, you can refer to Article 17(4) and D. So the D says that, there's a preamble, but the D says that for making different provisions for different communities, having regard to their special circumstances, not being provision which is inconsistent with the spirit of this Constitution. So clearly, from the onset, the Constitution itself says that it has A's spirit. What is the spirit of the Constitution? Now, anyone who has studied constitutional law in Ghana knows that in 1980, in the celebrated case of Tufo, an Attorney General, the late Justice Sowa made a profound statement that the Constitution has A's letter and it has A's spirit. Now, that was before the 1992 Constitution was promulgated. So when he mentioned this, a lot of scholars were skeptical about what that spirit could mean. Because how could a constitution, which is a document like this, have a spirit? So if you remember in your constitutional law, in 1993, in the case of the NPP versus Attorney General, Justice Atta just refused to, even understand and apply the spirit of the Constitution, saying that it was a transcendental concept that could lead to Kantian obfuscation, that famous, statement. But now we have come to embrace the spirit of the Constitution, which is that every provision in the Constitution is written against the backdrop of a certain value, of a certain fundamental principle, of a certain philosophy or purpose. And this purpose, this value, this principle, this core purpose is what we call the spirit of the Constitution. Now, the spirit means that the written provisions are not just there. They have not just been written there for the sake of writing. They have a purpose behind them. And I tell my students that when you live the Constitution like this, you see it is a document made up of articles, chapters, and clauses. But every clause has a purpose. Every article has some kind of value that it tries to, if you like, promote and ensure. So these are what you call the spirit of the Constitution, just like a seat belt. When the law says that wear your seat belt, that is the written provision. Then the question is, what is the purpose of wearing a seat belt? It is to save life.
Okay.
So the spirit of the law that says wear a seat belt is the safety or preservation of life.
Okay.
That's how it is.
Let's practicalize this concept of spirituality. How, and this question will be in two forms.
Yes.
One is, how should it be balanced during decision-making by judges?
Thank you very much. Now, you mentioned spirituality. The spirit of the Constitution emphatically has nothing to do with spirituality.
Not in the terms, in terms of spirituality
religious,
as we know
yes,
it.
no.
Yes.
It has nothing to do with faith, as in having faith in Christ or having faith in Islam, no.
Correct.
It is a matter of fundamental values. Values like probity, accountability, justice, rule of law, and all of that. So now coming to how this spirit, plays out in decision-making, particularly in courts, when a judge sits to administer justice, first of all, he must understand what his mandate is. The mandate is to administer justice. Justice is one of the fundamental tenets or principles or values of the Constitution, and it is part of the spirit of the Constitution. So a judge sits to, first of all, administer justice, knowing that every right is important, must be preserved, must be protected. And the judge must not take sides. He must ensure that the rule of law is applied. Now, when you go to the courts in Ghana, there is something that people haven't taken notice of. When you enter the court, just behind the judge, you see the Ghana Coat of Arms. And inside the Coat of Arms is written freedom and justice.
Should it mean anything to the person who enters the courtroom?
It does mean so much. What it communicates, the values it communicates are these. Now, to the judge, it is a reminder that as I sit here, my core duty is to administer justice and uphold the freedom of individuals. Now, to the litigating public who just enter the court with their cases, it gives them assurance that this courtroom is a sanctuary of justice. I'm not coming here for my rights to be denied. I'm not coming here for my rights to be taken away from me, but to be enforced. And to everyone watching from afar, it tells us that our courts are actually there to uphold justice. And so the spirit of the Constitution plays a key role in judicial decision-making. When a judge sits, the rights of people are just in the balance. And the decision of the judge affects people's rights one way or the other. But the overriding force that shapes the tilting of the balance or the scale is the spirit of the Constitution, which is fairness, equity, and justice.
Let me ask Benjamin for his thoughts on this concept of the spirit of the Constitution and how Daniel Cran explains it, breaks it down in terms of decision making. I like very much the idea that when you enter the courtroom, you should immediately realize that something is going to be upheld.
That's right.
Which is freedom and justice.
Yes. Of course, as has been read by the senior, the Constitution is quite clear that there are certain fundamental principles that underpin the black and white that you see there. Okay, and then the preamble to the Constitution is quite elaborate on these principles. But beyond even the Constitution, the mere even movement towards the purposive interpretation, as has been endorsed by the Interpretation Act, is quite reflective. And when we're talking about the purposive interpretation, all that you're saying is that it's not all the time that you focus on the letter of the law. There are some underlying reasons why the law was made.
So the spirit comes alive.
Purpose.
The spirit comes alive in that.
Is in the purpose. And that is why the Interpretation Act, again, makes even recourse to parliamentary materials or pre-parliamentary materials.
To understand
the minds, the intention of the
lawmakers when they were putting that piece of law together.
Sure. So you will see how elaborate the spirit can be spread out. Okay. So, but the point is that, you see, the Constitution also, under Article 1061, talks about the explanatory memorandum, which is one of the requirements that every bill coming to Parliament for passage should, have. And the sense is that you even tell the MPs, tell Parliament about the problem that exists, and then, describe the problem. Tell us what measures or provisions you have put forward to address those. Quite frankly, when the law is finally, passed by Parliament, assented to by the President, and then prepared, the Assembly Press does not print the explanatory memorandum as part of the final act that comes out of Parliament. And that is quite problematic because it holds a lot of value. The spirit that we're talking about. And I think that exclusion might have even accounted for some of our learned jurists asking, where is the spirit? The spirit is in what gave birth to the law, because people don't just sit down and come up with laws. There is a problem underlying factor that bring forth or give birth to the law. And these are what should be in the memory, not only in the judge or lawyers alone, but the people themselves, because that's the only way you understand the law. Let me give the case of Apia and Bieni, and you see that even though PNDC law 111 did not emanate from Parliament, but by way of a military decree, when the judge was confronted with ascertaining whether an uncompleted building was a building for the purpose of the law, which you go to the surviving spouse and children, the court said, definitely grammatically, when you talk about uncompleted building, it will not be a house, okay? But the learned jurist said, let me go into the reasons for the law. And part of the reason was the inequitable succession of property upon demise of the man or a spouse. And so the reason was for adequate provisions to be given to the surviving spouse and children. So to that effect, he went on to interpret an uncompleted building to be a house and gave it to the surviving spouse and children. So the spirit is everywhere, and mostly, in the minds and documents that, gave birth to the law.
So, so this answers the first part of the question. The second part is, do you see Ghana's judiciary consistently applying this principle that you just explained perfectly?
Yes, I would say that in the Fourth Republic, the Supreme Court of Ghana has been very conscious about the spirit of the Constitution. In almost every constitutional law case you hear and see the Supreme Court mentioning and enforcing the spirit. But as to whether specific judicial decisions and outcomes really conform to or promote the spirit, I cannot say yes. But
why not?
I cannot say yes because, you know, one thing about the spirit is that it is very fluid and it makes the whole constitutional framework a malleable something so that judges are able to introduce personal views and all of that. So when you go to the realms of spousal rights and Article 22, you will see inconsistent decisions about whether matrimonial property should be shared 50-50 or whether a spouse can even acquire a private property during marriage. See, the consistency hasn't been there. And it is because the spirit allows the judge to try to do justice even beyond the letter of the law. And that really is problematic because it allows what you call judicial activism. And so when you read this case of Atta Ayi, Justice Parl was clear that the Constitution does not clearly mandate the Supreme Court to try to enforce the spousal rights in Article 22 because that spousal right provisions were a directive to Parliament to pass law. Parliament hasn't passed the law, but the Supreme Court is enforcing the values in there.
Well, in the absence of that,
you see?
If you're going by this spirit that you've defined, then shouldn't that be the case?
It should, but it is also inconsistent with our constitutional framework in that if the Constitution says that after coming into force of this Constitution, Parliament shall make a law to enforce these rights. It is a mandate for Parliament to make the laws, and it is when the laws come to be that they could be interpreted. Now, Parliament has not made the law.
There's a gap.
There's a gap,
yes.
A clear gap.
But we also say that the Constitution is the mother. So if the child is not performing what the mother has given the child to do, what should the mother do? Benjamin wants to say something.
Yes, I'm itching to add, you know, with all due respect to senior, I don't agree with that suggestion that, you know, this, you know, a mandate to Parliament. So once Parliament has not acted, then we should sit, you know, unconcerned. But particularly, if you read specifically 22(3), it tells you, he has given you some of the provisions that the law that Parliament should pass will be. So in other words...
Respectfully, could you read that part
yes.
if it's open?
So the explanation is that it's as if the law exists and some of the provisions are there. And that has been the concern, the province that the court has used to do that. So Article 22(3) says that with a view to achieving the full realization of the rights referred to in Clause 2 of this article, A, spouses shall have equal access to property jointly acquired during marriage. B, assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of marriage. So what the Constitution has done that before Parliament passes the law, these are cardinal principles that exist. And in fact, Parliament cannot pass the law without inclusion of these provisions. So in the absence of the parliamentary action, the law partly exists. And that is where I disagree a bit with the proposition.
Right. Before we move on to, I wanted to bring the fact that there is entrenched and non-entrenched provisions of the Constitution. Please quickly. And then there's something that you said that I want to draw you back.
All right. So on the issue of spousal rights to property, let's listen to Mensah and Mensah 2012, okay? This is what Justice Dochi said. From the above provisions, referring to Article 22, it means that the framers of the Constitution mandated the Parliament to enact legislation to regulate the property rights of spouses. It is a sad reflection that since 7th January 1993, when this fourth Republican Constitution came into force, the above directive has as yet to be complied with. Suffice it to be that there is now before Parliament a bill in fulfillment of Article 22 of the Constitution. It is also important to note that Article 22 that he said give an inkling of what the said legislation should contain. So clearly, the Supreme Court knows that and acknowledges that Parliament has defaulted, but the Supreme Court will not sit aloof. So they would enforce the principles that the legislation is to enforce. But can you enforce a principle based on a legislation yet to be enacted? Well, this is how fluid the spirit is. And it allows judicial activism. And this is a clear case of judicial activism.
Okay, so let's stay on that activism. Is there something in connection with...
Some fact to... the question is, why hasn't Parliament passed that law?
This bill
has been a government bill. It's been a government bill. It's been around for quite some time. Because
when you say it's a government bill, it means that it hasn't found its way to Parliament yet.
No, it's introduced by the executive through the ministers, okay, because of financial limitations. You read Article 108. There's a limit as to what Parliament can do, but this is just put aligned with Article 93(2) of the Constitution, Parliament being the supreme lawmaker. That is why that provision is there. So even though it sits as a direct mandate to the House, it's not exclusively the mandate of Parliament to pass that bill.
Just to be clear, we are not saying that the reason that bill has not found its way to Parliament,
it has
gone through the consideration stages and been passed, we're not saying that it's because of financial reasons. That's not what we are saying, is it?
No, not financial reason in the sense that a private member's bill, which will be Parliament its own initiation and passing a law, if you read this one literally, that is what it suggests, that Parliament by itself could make a law like that. But this law, I'm saying that by virtue of the limitation or restriction under Article 108, that bills having financial implication must be introduced on behalf of the government. So a private member cannot do that. But I'm saying that in the past, the attempts at making this law, there's been several attempts. That attempt emanated from government, and then there were several issues that stopped it from becoming a law. And so, when you read it literally, you will say that as if it's Parliament that has defaulted per the judgment or the dictum that has been read. But I'm saying that there's not a law that Parliament...
So it's onto the executive and not...
Both, all of us.
And not the legislature.
How much have we demanded for that law?
Okay, well, that's something for us to think about and debate, I guess. But I want us to go back to the activism you talk about, Daniel Kran. And you remember you said the judge's own personal views can be incorporated in that decision that he's taken. Am I right in saying this is what you said? This is what you meant?
You see, when a judge sits to decide cases, there is something I call the procedural quiver. The quiver is the bag in which the judge has his tools. And inside the quiver, he has his knowledge of the law. He has, I didn't say he has the law, but his knowledge of it. You see, it is one thing to say that this is the law. And it's another thing to say that this is the judge's understanding of that law.
Right.
So understanding is personal and not general. So that is why a judge of a lower court can take a decision based on a law, but a judge of the superior court will say, no, this is not the law. Why? Because the understanding of the law is influenced by the judge's personal traits, including his ability to understand, to learn, even emotions sometimes. But they are not supposed to be. So when it comes to matters like spousal rights, and you read the cases very well, you can even see that sometimes you want to believe there are some gender issues in there. There are
gender considerations. Back in the decisions.
Exactly. When a judge is a father of daughters, you see, I have 2 daughters.
And I
so
have 3
you have 3 daughters.
One boy.
So if you sit as a judge to consider whether a wife should have 50-50, definitely you're going to have your daughters in mind.
And there's nothing wrong with that, is it?
That is why it is correct to say that personal views often influence judicial decisions, even though they may not be clear on the surface.
Okay, so let me just drop in one that has been talked about a lot. The Chief Justice's vetting, where he made a disclosure in terms of what went into the sentencing.
Of Atta Ayi.
Exactly.
Good.
What was wrong with that?
Now, you see, in every decision, we have the spoken or written component and the unspoken or the unwritten component. So if I sit to judge somebody like Atta Ayi, clearly I will be applying the law on sentencing. But inwardly, I will be enforcing some fear in me, which is that if I should release this gentleman, my children, my wife, my family, my friends, and society generally will not be safe. But the judge might not pen these things, these considerations, he might not write them. So,
in his judgment.
In his judgment. But these are the hidden, unwritten considerations. So when we take decisions, we often declare some of the reasons for taking the decision the way we took them. But there are some unexpressed considerations. So for a judge to say that I sentenced this guy to this length of imprisonment because personally I feared, I think it is not wrong for a judge to fear. It isn't wrong. Because
the judge is human.
He's in society.
He lives within society.
I think what Justice Baffoe Bonnie said was the expression of the common Ghanaians' feelings. Because it is never safe for a convicted armed robber to be released into society within the shortest possible time. It is never safe for any of us. And so for him to have now told Parliament that I did this because of this.
Oh, he was speaking to all of us.
All of us, actually. I'm not sure he was wrong. And Ghanaians, you understand that judges take decisions not for their own sake, but for the sake of all of us. So what he expressed is for all of us, and not for himself and his
For the good of the society.
For the good of society, yes, generally.
Yes. But I know that you hold a slightly different view on this. Would you want to express it?
Different view.
Okay.
A completely different view. Yes, as Senior has said, there are theories that guide judges when they are imposing sentencing. Retributive, utilitarian principles. There should be some benefit for punishing people and not just punishing people. Okay? But the point is that there should be predictability of the law. A bad man, you read the bad man principle. What would the court do, in fact, when I'm put before them? Okay, but if I am put to now think into how a judge will feel, I think that is off the principles of justice. Okay, principles of justice, you may do it, but of course, to express it to, the people, the subjects of the law, and also looking at the forum. I think that, to justify this kind of statement is difficult for me. But I take solace in the fact that it was said on a lighter note. So for that purpose, that can be allowed. But we should not say that you should allow your idiosyncrasies. Read Article 296, it's clear. Decision making, when you're exercising discretion, you are bound, you have a duty to be candid, to be fair, and all those things. So if you put your personal safety and some, considerations into your decision-making, that to me is not good. But I take it that it was made on a lighter note.
I want to believe that this does not mean that in every single decision that a judge takes, they would bring their personal view in terms of...
The point is that even if it's one is honest.
To bear. But I want us to move forward, and I want to ask you, there are entrenched and non-entrenched provisions in the same constitution that you talk about.
Yes.
So how does this spirit play out in the entrenched provisions?
All right. When you read the amendment chapter, I think chapter 25 of the Constitution, it says that some of the provisions are entrenched and others are not entrenched. Now, the nature of entrenched and unentrenched relates to the difficulty in amending those provisions, but it does not highlight their importance. It does not mean that the entrenched ones are more important than the unentrenched ones. It doesn't mean that. It only lays down a more difficult procedure for amending one and a less difficult procedure for amending the other. But wherever there is a human rights provision in the Constitution, no matter where it is found, it is treated as human rights, no matter where it is. And thankfully, I see that almost all the human rights in the Constitution are entrenched. The provisions are entrenched. And if they are entrenched, it means that we need to follow what we call a referendum to amend them. Sometimes, most of them, we need a general referendum. But those that are not entrenched, you go to Parliament and you follow the normal process.
It just means that the process is a little more rigid.
A little more rigid for the entrenched and less rigid for those that are not entrenched. But it does not make one more important than the other in terms of their substantive value. Yes.
So now that we appreciate the spirit, we appreciate the fact that there is a purpose for the provisions, for the laws, and that's in interpreting the Constitution, for instance, they have to go back and look at, those purposes, for instance. If you only interpret based on the letter, then I guess it will be dangerous, right? It means that you're leaving one aspect of it out. Is it? Am I correct?
Exactly. You see, every written provision has an underlying philosophy or purpose. And the moment you read the literal meaning of the words, you have to interpret to enforce the purpose, which is the spirit. So you cannot divorce the letter from the purpose. So this Justice Sowell again, in 2-4 Attorney General said, the spirit and the letter they are inseparable bedfellows. They are inseparable in the sense that you can never separate the spirit of a man from himself and still have the man living. So once your spirit leaves you, the body, which is the letter, goes down. And so if you want to ensure that the Constitution is properly interpreted, you can never ignore the spirit and try to enforce the letter.
But there are times that we have ignored the spirit.
That is a disaster. You see, the spirit breathes life into the letter. That's what we have learned. And so the moment you ignore the spirit, you are going into what we call dry legalism. Dry legalism means that you are just enforcing the literal meaning of the written words. And that could only enforce legal justice and never substantial justice. You see, we have legal justice, which means that justice according to what is written. But that might not lead to just outcome. So we have difference. You see, justice, there are so many different kinds. So you read a letter that says that, let's do this. Then you go strictly, literally. That is justice according to the letter. But we have justice according to the spirit, which means that we are enforcing fairness and just outcomes.
This spirit, does it evolve beyond the purpose, beyond our core values? Does it also evolve with the trends?
Yes, you see.
With lived experiences.
Exactly. There's something we call the living constitution theory. When we say the living constitution theory, it is a concept that says that the Constitution is not a static edifice or static legal document, but it is a living organism that is capable of growth, capable of expansion, capable of development, capable of progress. And the progress aligns with trends. Society evolves, so the law must evolve as well. And the evolution is such that we want to always ensure that our modern views of fairness, justice, freedom, human rights, democracy must not be divorced from what we have written. Mind you, this letter was written in 1992. How many years now? Over 3 decades now. But we know as people that so much has changed in terms of our values, our understandings, our practices, our culture, and all of that. How do we get this ancient document to still apply to modern people? We have to ensure that this document evolves, and the evolution is driven on the back of the spirit of the Constitution.
Right. So how should judges and lawmakers, and this is, I'm bringing in lawmakers so we can jump to the other half of it. How should judges and lawmakers, in looking for, in trying to be guided, should it be just the framer's intent? Should it be lived experiences? Should it be, how should they search for it in arriving at what they are seeking to interpret?
That's the sources of the spirit. Mm-hmm. You want to talk? Yeah.
Yes. So, and before I do that, let me quickly respond to this statement that you often hear, that now the Supreme Court, at one point will interpret a shah to me may and may to be a shah. Yes, in talking about the spirit which informs the kind of interpretation that comes out, it's not all the time. Sometimes, the spirit accords with the letter. So in that case, then there's no point to move. But where there's some disagreement, okay, so when you go
where
to
there's
literal,
ambiguity,
and that is the purposive
where it's
approach.
not clear.
It's only when there's some ambiguity or there's some absurdity, it will not be intelligible to construe the black letter. That is when they depart. If not, they stay. We remember the Ananis case. Okay, the Supreme Court stayed. Okay, and said that there should be a formal complaint before SRAT can proceed with investigations, and then the outcome can follow. Okay, so it's not all the time. It's not all the time. So where the point is that our interpretation act is clear. Don't construe letters, as they exist. Make sure that they reflect the purpose. And the purpose, as we said, you can find it in several places. Through the intention of the lawmaker. And then even sometimes, the text itself, when you read it and think, you ask why this provision, you are likely to find the spirit. When Article 49.3 came into the question in the 2012 election petition, the Venerable Tuguba asked the question, what's the magic of the signature of the presiding officer? Is that not the question that was asked? So you are interrogating why this rule. Is it something that we must stick to, or there's a reason, there's a good reason, whether current development or for some other consideration, that there's a need to depart? So the court does not just depart. The liberal, elaborate, the freedom when it comes to interpreting the Constitution is all to make sure that the Constitution is given that effect and meaning of being a living organism capable of growth and development to reflect and meet current needs.
Sources. You see, for constitutional law students and practitioners, sometimes when they hear the source, the spirit of the Constitution, they are wondering where it can be found. I have mentioned here that the Constitution itself mentions that it has its spirit. And so one of the fundamental sources of the spirit of the Constitution is the Constitution itself. Now, in the preamble to the Constitution, it mentions certain core values. So anyone who is studying constitutional law, listen carefully. When you look at this, the preamble is here. It mentions in the name of the Almighty God. This is part of the spirit. It highlights the religious.
But we have said that the spirit is not spirituality.
Yes.
As we know it, as in religious spirituality.
But the magic here is not the God you heard, but the fact that the Constitution acknowledges God. So it means that Ghana is a religious country, but never a Christian country or an Islamic country. It means we have religious plurality, right? Everybody can serve a God. Now, we, the people of Ghana, you see here, is part of the spirit. This is what you call popular sovereignty. It means that the Constitution was designed, promulgated, and given by the people unto themselves. So when you see we, the people of Ghana here, it is part of the spirit. It tells you that this Constitution was not given by government. It was given by the people unto themselves. Now, you see our affirmation and commitment to freedom, justice, probity, accountability, universal adult suffrage. All of these are part of the spirit, and they are captured expressly in the preamble. Now, beyond the Constitution and the preamble, we have something we call political history, the political and constitutional history of Ghana. our history informs the provisions here. So when you read Article 3(1) of the Constitution, it says that Parliament shall have no power to enact a law establishing a one-party state. So Parliament of Ghana cannot make a law in Ghana to say that we are a one-party state. Why? Because our history tells us that Dr. Kwame Nkrumah did it. You see how it is. So the Constitution was made against the backdrop of the wisdom that we derive from our political and constitutional history. And another important source of the spirit is international human rights norms. So when you read Article 33 of the Constitution, it's 33.5, I think, it says that if we are considering the human rights provisions, we don't have to consider them as exhaustive, but we have to consider them as also incorporating other values that are enshrined and practiced in other democracies.
Right.
What it means is that the Constitution opens a window for us to go or emplain and go to other democracies and fetch whatever is practiced there which we think are in tandem with our understanding of democracy.
Right.
So the Constitution is really a rich source of the spirit itself. And our evolving consciousness, as you said, you know, our consciousness evolves.
Yes.
And as it evolves, we try to have new, fresh understanding of matters. And all these guide the growth of the Constitution.
Right.
Judicial interpretation, all of these are part of the measures to ensure that the Constitution lives as an organism.
All right. And I guess another important source is Parliament itself.
Parliament
is
itself.
The process of making the law. And that brings me to the fact that we often see the mother law being made. We talked about the bill, which has not found the spousal bill that we did mention. There's a heated debate about misinformation. That's also another bill. Yes, we often hear those ones. But the other legislation that would ensure that the day-to-day, you know, whatever it is that has been enacted comes alive, we don't hear much of. So let's look at subsidiary legislation, which you have also written on. Yes.
So there's a very important subject that is dear to me, you know, because the law, the Constitution, or an Act of Parliament will establish broad policy framework detailing specific things that can be done. But it is the subsidiary legislation in the nature of constitutional instrument, legislative instrument, executive instruments, bylaws that will give flesh and operational rules. And these operational rules are what will affect you and I more directly. There are certain laws that without the flesh, the additional rules.
So why is that not popularized? I mean, we hardly hear, except for maybe CI's regulatory elections, then everybody is counting. We know that it matures in 21 days. But apart from that, most of the other ones, we don't hear.
Yes, and that is why in my modest attempt, I have always had a dream of bringing out this book. Okay, so it is we have a common duty to project what matters to us.
But if the people are empowered to know about subsidiary legislation and how that comes alive, what's the use to them?
So the subsidiary legislation is part of the law. It has the same force as the Constitution, as an Act of Parliament. So the people must know this is what directs their affairs more directly. But the point is that because we have a larger illiterate society, there's always the perception that, oh, the law belongs to only lawyers, as if it's a private tool.
Okay, so
but it is for all of us.
Quickly explain to us how that lawmaking process is like.
Okay, good. So to start with, you first have to even identify what these subsidiary legislation, the components, what they are. And as I've expressed, you have constitutional instruments, legislative instruments, bylaws, executive instruments. These are produced as a result of power delegated by the Constitution itself or by Parliament. Okay, so when in an Act of Parliament, Parliament says that Parliament establishes, let's say, Ghana Gold Board. I say Ghana Gold Board can make regulations to regulate the sale of products made out of gold. That is a power given. Okay, so this power when it's being exercised, it's made by the minister in conjunction with the, let's say, the office of the Attorney General. But when it's so made, it has to be placed before Parliament. That's if it has legislative character. Not all subsidiary legislation is supposed to be laid before Parliament. But the example I've given you has to be laid before Parliament. And when that is done, then the same day it's laid, it has to be gazetted. And when gazetted, then it has to be before Parliament for 21 sitting days, not ordinary days. Only days that Parliament sit, that is what is counted. Okay, so that even brings in some alignment with parliamentary language that later I will come to. There are certain words that are used in Parliament that have constitutional implications. Okay, so sitting day. Why 21 sitting days? Because to the framers, that gives sufficient time to Parliament to annul the instrument if it deems fit to do so. So that is where I have made a comment that where Parliament is deprived of access to the instrument from the very day that is laid, then you are depriving the House the opportunity to, stop a defective instrument from becoming law.
Please explain. That sounds a bit technical. What do you mean?
Okay, what I mean is that when an instrument is laid before Parliament, it has to be there before Parliament 21 sitting days, not ordinary days. You've heard about the case of, there's not a judicial case, but the case of Kolebu Teaching Hospital. There was a point an instrument was laid before Parliament. It had not achieved the 21 sitting days, and they started charging. It took some members to draw their attention, and that is why it's crucial. But I'm saying that the purpose why the 21 sitting days is to afford members the opportunity every sitting day out of the 21 sitting days to come up for an annulment motion if he finds that maybe some provision is defective or it's unconstitutional or isn't consistent with the power on which is being exercised.
Because Parliament itself cannot make any corrections. It has to go back to those, who put it together.
That is a very important feature about subsidiary legislation. Parliament cannot even start the process.
Right.
And it cannot even bring to an end an existing instrument. That is why when the call was made that, it's Parliament's duty to even revoke the existing, I think, LI 2442 about mining in forest reserves.
All right.
I kept educating that is not the mandate of Parliament. Parliament cannot delegate power and then, take the power back.
All right, so let's just hold your thoughts there, because one of the other things that we're doing is for our viewers to also participate in this conversation. We have someone joining us on the phone lines. Nelson is on the line, and Nelson is calling from Sunyai. How are you, Nick? Good morning. Good afternoon, Nelson. Thanks for joining us.
Good afternoon.
Yes.
Good afternoon.
Yes, Nelson, we can hear you loud and clear. Please go ahead.
Yes, thank you so much for the discussion. I want to put this question across. I want to ask that based on what is discussed, first of all, with regards to the spirit of the Constitution, can we boldly say, from the understanding being made today, and I've learned a lot, can I boldly say that the petition to remove the Chief Justice was made on the basis of the letter of the law, but not on the spirit?
What is informing this question, Nelson?
Come again.
What is informing this question? Because we've been referring to interpretation and the processes of lawmaking. But you have introduced, this was a petition. So I'm asking what is informing your question.
Yes, I'm asking it because from a layman's perspective, if I read the petition and the mannerism with regards to how those things were conducted, from my own layman's view, I may interpret it as based on the letter, not on the spirit.
Okay, so Nelson. Thank you very much, Nelson. The process was in camera, correct?
Yes, I mean, they followed the Constitution, and so...
So the letter, not the spirit. That's what he's saying. Anyway, we'll come back to that if there's anything more to say. But there's somebody else on the line. Francis is joining us from Akuse. Francis, good afternoon. Thanks for joining us. Please go ahead.
Yeah, good afternoon.
Good afternoon, Francis.
My question is straightforward. I just want to find out how come that sometimes the law or the judges made us confused or get confused. Because when you travel every part in the world, I mean, a place like Togo, Benin, Nigeria, all over the world, the first thing that they look up for is your passport.
Francis, I'm not hearing you clearly. Could you just take your time and then ask your question, please, so that we can follow you?
What I'm saying is that it seems sometimes the judges or the lawyers make us confused. We the subjects confused because when you travel to other parts of the world, that makes a man, a citizen, or a nation, a person, a citizen of that country is your card identity or your identity card or birth certificate or passport. But how come that Ghana, we declare ours? It's like somebody has to prove to you that or declare you to be a citizen. You can't just use that as a proof that you are a citizen of that country or Ghana. Why do we have ours different from the other part of the world?
Okay, Francis, I think I have an idea what you're saying. We appreciate. We'll try and see if we can help you with some sort of answer. But thank you so much for calling. Caddy is calling us. Teddy, I beg your pardon. Teddy is in Laboni. Hello, Teddy. Hello, Teddy, you're on air. Let's hear you, please.
Yeah, good afternoon.
Good afternoon, Teddy.
What is the criteria?
I'm sorry, Teddy.
What is the criteria of certain Chief Justice? The criteria of choosing a Chief Justice, the criteria.
I'm sorry, you said what is the criteria for
choosing a Chief Justice?
Removing or
for choosing a Chief Justice.
Yes.
Oh, okay, Teddy, thank you very much. It looks like we've opened the doors. We're getting questions, out of the discussion area. Would appreciate it if you stick to what we are discussing. That will be helpful. Bishop is our very last call. Hello, Bishop. Good afternoon, Bishop. Yes, Bishop.
Yeah. I have been listening to you, and I wonder why is it that the spirit of the Constitution, which have been explained, the purpose, so of writing, is not made available to the public and to lawyers. So to save us all debate and the confusing lawyers take up. This lawyer will say means this, another person will say it means this. Now it's what then the spirit of the Constitution should be very simple. It should just be very, very, if we have them written down so people can easily refer before and all things. But lawyers can do a whole of this. One thing, different lawyers say different things about it. Yet the spirit of the Constitution remains. Thank you very much.
Thank you very much too, Bishop. We appreciate the point that you're making. And I think that's the whole idea of something bringing this program, The Law, is so that you, the people, can also be empowered. But I think today we've had a very fruitful discussion in terms of where to find the spirit. We've taken you through exactly where you can find it so that you can also appreciate the decisions that are made sometimes. But I think that we've also agreed that there are times that decisions are made, based on only the letter because you can't necessarily find the purpose.
Oh, I would not think that there is any time that decisions are made based on the letter. When we say decisions are made based on the letter, it means you are limiting the understanding of the spirit. The spirit connotes that behind every letter, there is a purpose. And so when the letter is so clear that no serious interpretation needs to be done, and you are enforcing the letter, what you are doing is essentially enforcing the spirit behind it. So the spirit is when you say that this constitutional provision says this, and I am enforcing it. So that's the spirit. So we should not think of the spirit as something esoteric or something spiritual or something transcendental. It is not. It is not a deity.
On that note, you have a book on the spirit.
Okay, so all right.
Tell us about it.
All right, so this is a book that I wrote recently to mark my 10th anniversary at the Ghana Bar.
Congratulations
Thank
to you.
you very much.
Congratulations.
As I turned 10 this year, specifically on 2nd October 2025. I got 10 years, and I wrote 2 books to mark that wonderful anniversary.
Right.
One is The Spirit of the Ghanaian Constitution. Now, this book unveils the spirit, demystifies it, and explains it in such a manner that the ordinary person would understand.
Right.
And it is a very wonderful material for constitutional interpretation. So just this morning, I presented 20 copies, free copies, to the Supreme Court of Ghana, to all the judges. So I handed them to the registrar.
That's very generous of you.
Yes, thank you very much. So I did this to enhance our understanding of the Constitution.
All right. So where can we, the ordinary people, find it?
You can get this. You can get copies here in Accra at the court premises. You can go to Kingdom.
When you say the court premises,
the
High Court, Supreme
complex.
Court, okay.
The court complex, you get some. There are some book salespersons there.
Right.
They sell them. You go to Kingdom bookshops, Legon, KNUST, and Ghana School of Law, you get some.
Okay.
Yes.
All right. Benjamin, you also have your subsidiary
Thank
legislation
you.
out there. In fact, you also have 2.
I have 2 for now, and I'm inspired by my senior. Next year, I will also be 10 years at the bar, and I will do 3.
Wow.
I will do 3 because some are already in the works. As for reading the law, is a book that is well known. It must be found in every home, because as you said, the law is not the private tool for the lawyers alone. It regulates our affairs in so many ways that without it, you are not guided, you have a challenge. So for particular publications, these 2, this is subsidiary legislation in Ghana, as you have said. This is a law that touches us so much closely, but we know little about it. It's a very important subject, even determining which instruments must be laid in Parliament.
All right.
But talking about even bylaws.
So where can we find it? We put it on the screen so viewers can appreciate
it's yet to be launched.
Oh, okay.
So on Thursday, all these 2 books
will be launched.
It's been launched, on the direction of the Speaker of Parliament and the leadership of the House.
All right.
Okay, this is an important book telling you that Parliament operates with a special language, which has constitutional implications.
All right. Congratulations to you both.
Ghanaians.
Sir Dennis will be very excited. He wants, almost every person linked to the law to write. So thank you very much for sharing. We thank you for watching. Thank you very much for contributing to the program as well. My name is Mama Vio Uswabuaje. On behalf of the production team, we thank you for watching.